Afternoon and welcome to the second webinar of the Pretty's Commercial Property team. I'm Graeme Burslem, I'm an associate in the team, and I'm joined by...
Hello, I'm Rebecca Cleal, Senior Associate and Head of Commercial and Residential Property here at Pretty's. Thank you all so much for joining us today. Weather's not quite as good as it has been, so maybe nice to get in on an afternoon and catch up on some interesting commercial property info. Before we get started, just a couple of housekeeping points. Hopefully you'll see on the bottom right hand side of the screen we have a Q&A box. So if during the webinar you feel that you have a pertinent question to ask, you can always type it in that box and Graeme and I will see it and hopefully be able to respond. Obviously, if we have numerous queries on a particular point, we may have to stop and then come back to those queries at the end of the session when there will be time for questions. And secondly, we would love it if you would be kind enough to give us some feedback at the end of the event. You'll see a feedback box and hopefully you will respond favourably after today's session. So I'm now going to hand over to Graeme, who's going to run through a bit of detail about what we're going to cover today.
Thank you. So we spoke last year, roughly a year ago, around the time of what's become affectionately known as the first lockdown, to introduce you to some of the pertinent provisions of the Coronavirus Act and some other supporting legislation introduced by the government around that time. So what we thought we were going to be doing today would have been giving you an update as to the position going forward, because we had obviously anticipated that the relevant date in terms of the lifting of the restrictions on landlords in terms of their ability to forfeit tenants' leases, we had anticipated that was all going to come screeching to an end on the 1st of July, but as of yesterday apparently that is no more. So what we're going to do today, nevertheless, is to talk to you about some topical points concerning commercial tenancies and the position as to where we are now as regards landlords' relationship with tenants and enforcement remedies. And we're then going to give you a quick update on some planning points that have arisen, and we're then going to look at what we've seen recently in terms of property finance and developments, and then we're going to leave you with some humble thoughts, observations as to what we think we might see over the following 12 months. So, starting at the beginning then. So, as we know, as we went into the first lockdown, and this hit commercial tenants pretty hard, especially obviously those in the retail and hospitality sectors who suddenly found themselves at what with people being told to stay at home. The tenants found they weren't getting any shortfall for their businesses, and so set against that background there was widespread nervousness that tenants, well, they were going to go bust and they weren't going to be able to pay their rents. And then to add insult to injury, there was a worry that commercial landlords might have used this as an opportunity to swipe back their leases by forfeiting them. So the government introduced, firstly, the Coronavirus Act 2020 to place some temporary restrictions on landlords' ability to forfeit. And it also enacted the snappily entitled Taking Control of Goods and Certification of Enforcement Agents, brackets amendment, brackets Coronavirus Regulations 2020. So let's just take a very brief refresher as to what those actually did. So the Coronavirus Act, so far as it related to commercial property and commercial tenancies, the most relevant part of this was that during the relevant period, as defined in the Act, this placed restrictions or prohibitions on a landlord's ability to take steps to forfeit relevant business tenancies on the ground of non-payment of rent and other sums falling due. And it also had the effect of postponing, pushing back the effect of any possession proceedings which were already in train or that people were planning on issuing. So whilst we had anticipated that these provisions were going to come screeching to a halt on the 1st of July, these have now been pushed back to the 25th of March 2022. So we're going to be living with them for a little while longer. So if I now hand over to Becky, who's going to talk about what the effect of these actually is.
Thanks ever so much, Graham. Yes, needless to say, first thing this morning, we were very much hastily updating the notes in this presentation for you. So this is very much hot off the press. So the restrictions, which were due to come to an end on the 30th of June, 1st of July, are now being pushed back until the 25th of March 2022. So what that means is we are effectively still in the same position, which means that a landlord is unable to bring a tenant's lease to an end for the non-payment of rent or any other sum payable under that commercial lease document. The one thing we would remind landlords of is that it does only affect commercial tenancies. Residential, I would taking to one side, but when I say commercial tenancies, I mean those that are categorized as business tenancies under the Landlord and Tenant Act 1954. So people occupying property for the purposes of a business. It's also worth remembering that actually other tenancies, so agricultural holding tenancies, farm business tenancies, and short-term tenancies, so those granted for less than 6 months, are unaffected by these provisions. So if you've got one of those, you may still be in a position to forfeit. If you are one of those people that had served a notice way back prior to March 2020, unfortunately now you still can't serve a possession notice, and that's now being pushed back again until the 25th of March 2022. One thing we would want to make landlords aware of is that you don't impact your likelihood to waive. So one of the things that Coronavirus Act does, it says that landlords will not waive their right to forfeit if they don't seek payment or recovery or forfeiture of those sums due. So it's like there's a bubble. We were obviously going to be saying that after the 30th of June, you need to be careful that you don't accidentally waive the breach. But again, we are still in the status quo. If you are in the throes of a Landlord and Tenant Act 54 renewal and you were considering not granting a tenant a renewal lease on the grounds of non-payment of rent, well, unfortunately, you still can't use that ground to not renew a lease. Again, that all falls within the Coronavirus Act, and all of those provisions are being pushed back to March 2022. A point that we would obviously just reiterate is this does not stop landlords forfeiting leases for other breaches. So that could include things like non-compliance with tenant covenants, in particular, for example, repairing covenants. So if a tenant has disappeared off into the ether and the property is sliding quickly into disrepair, then you may still have grounds to forfeit on that basis. So what are the new proposals hot off the press as at yesterday? Well, as I said, there is this 9-month extension on the provisions. And it's interesting because all of the other previous extensions of this piece of legislation have been for periods of 3 months. So this 9-month extension is actually quite huge and quite stark. The theory and the reason behind it, from the government's point of view, is that it was to ensure that those sectors who were unable to open have time to come to an arrangement with their landlord without the threat of eviction. But it's quite clear that this extension is not intended to be limited to the hospitality sectors. So it's pretty much business as usual under the current provisions for all parties. Okay. Bear with me. Thank you very much. Okay, so commercial rent arrears recovery. Under the situation pre-amendments, the ability for a landlord to be able to enter into this process was where there were simply outstanding rents for 7 days. The Coronavirus Act substantively pushed back those levels of debt that needed to be in place before a process of recovery under the commercial rent arrears recovery scheme could be entered into. So you will see from the table on this slide, it went from 90 days and then up and up and up, and ultimately, as at the present, it still has to be 554 days worth of accrued rent, which is effectively 6 quarters worth of rent, which is it's a huge amount. So in terms of an update on this, again, those limitations that you saw on the previous slide, and again, all of these slides will be available to you after today's session. All of those limitations will be in place until the 25th of March 2022. It is said that that minimum threshold of 6 quarters rent is not set to increase. So they're not planning on increasing that level of arrears any further. So by way of example, a tenant who failed to pay rent from March 2020 to June 2021 may still be protected from recovery under the Commercial Rent Arrears Recovery Scheme if they ensure that their net arrears were less than the 554 days worth. But tenants will have to pay September quarter onwards to avoid that enforcement. However, and this is the potentially, well, exciting, but also interesting bit that was announced yesterday. There is actually intended to be a new bill proposed to deal with the accrued rent arrears from commercial tenants during that relevant period. Okay, so not only are they, they're actually going to be setting out legal grounds as to how landlords and tenants have to deal with those arrears that have accrued within that period. In the information that has been released to date, nightclubs and hospitality venues are mentioned specifically, but obviously we don't know if that's going to apply to any other sectors. The emphasis is on that unpaid rent being ring-fenced. Now, what we mean by ring-fenced, what is meant by that, we don't know until we see the detail of the bill. But the driver behind it is very much going to be that landlords are going to be expected to make allowances for this ring-fenced rent, and it is expected that both landlords and tenants will share this financial impact together. It's even gone so far as to say that this can be done by a landlord waiving some of the amounts owed, or by agreeing sensible repayment plans. I mean, obviously, this is not going to be welcome news to landlords if they thought that they had been able to come to some long-term arrangement with tenants. There may be justification now that they might actually have to waive some of the rents if this bill goes ahead. The important thing to note about these proposals is that if agreement cannot be reached between a landlord and a tenant about how these ring-fenced rents arrears are going to be dealt with, then the matter will proceed to final and binding arbitration, actually going through a private arbitrator to make a judgment call on how that ring-fenced rent should be dealt with. So that's very new and very different, and we've not seen anything like that before. The important thing obviously to bear in mind is it won't affect any debt accumulated before March 2020 or after the date that trade restrictions are lifted. And of course, this date is to be confirmed when this is coming into force. But just so everyone's aware, I think this will come in. Now, obviously, it will have to go through, both houses of Parliament and could be rejected at either stage. But the general consensus is that there is a driver towards protecting commercial tenancies and protecting businesses. So I don't see any reason why this won't go through. But it'll be really interesting to have a look at the detail of this, whether or not it's only going to affect hospitality, whether they're going to widen that, what they mean by ring-fenced, and if there are going to be any sanctions, for example, on landlords for non-compliance. So this could, in theory, be a big stick that tenants can wave if they are in financial difficulties. Okay, so at this point, we were actually going to ask you the question whether or not you are planning to take any forfeiture action after the 30th of June, but obviously that's now been pushed back. So we've kind of rephrased the question, and it's going to be asking if you had been able to forfeit on the 30th of June, would you have done so? So hopefully you should now have a polling button. So it would be really helpful if you could vote and we can then see the results. Okay, can't see any votes right now.
Oh, there we go.
There we go. Yeah, so that's quite even. Oh, more coming through. We'll just hold on for 1 second.
It's like your revision.
Yeah, exactly. Almost as exciting. Right. Okay. I'm going to call it there and share the results. Okay. So looks like we've got 13% didn't have any plans, 25% of you did have plans, and 13% of you weren't sure. Okay, so there was actually going to be quite a few of you that were planning to forfeit leases. So that's going to be a bit disappointing for you then with that latest announcement. Okay. Just go back to the presentation and there we are. Thank you for that, everybody. So I'm going to just pass back over to Graeme, who's going to talk to you a little bit about the code of practice for commercial property relationships and what's happened with that.
Thank you very much. So, last year the Ministry of Housing, Communities and Local Government published a voluntary code of practice for commercial property relationships during the COVID-19 pandemic. But as we all know what voluntary uptake of voluntary codes is generally voluntarily like. So yeah, the idea was that this was to promote openness, transparency, straightforwardness, and generally, it was to promote an environment where landlords were going to help their tenants through the pandemic, and tenants were going to do their best to, in a sense, help the landlords by doing what they could to actually pay the rent when they could. However, things didn't necessarily go according to plan, and the effect of the code is going to draw to a close on the 24th of June. But to the point of it was to encourage people to do things such as agree concessions, agree deferrals, and in some instances, if you had a particularly generous landlord, maybe a waiver of rent. But this does seem to now be being superseded by the bill that Becky's just mentioned, in as much as we're now going to have something, presumably, assuming it does get passed, which is going to add a framework with teeth. So that landlords and tenants will have to, well, perhaps be persuaded to make nice rather than volunteer to make nice. But we'll see what the effect of that is when it happens. So yes, there was hope, although it was a voluntary code. There was some hope / expectation that that people were going to implement the suggestions and what have you, and there was some kind of optimism that parties' adherence or non-adherence there too might have been factored into some court decisions, but that didn't turn out to be the case, as was seen in the case of Commercial versus TVS Stores Limited, mentioned at the bottom of that slide, where effectively what happened was a landlord brought proceedings against a tenant for failure to pay rent, failure to pay service charge, and failure to pay what seemed to be various other things, in respect of which the tenant raised defences along the lines that, well, you as my landlord haven't actually complied with or taken any of the suggested steps under the code, and surely these proceedings that you're bringing against me now are just a cynical attempt to get around your inability to forfeit by kind of by forcing me out of business. And the court turned around and said, well, that's all very interesting, but no, it is a voluntary code. And fact is, you were contractually obliged to continue to pay those things, and you didn't. So here's an order against you. And so, yeah, that is the effect of voluntary codes. But as we say now, likely going to be replaced by the bill that Becca is talking about. So what else can a landlord do? I mean, in the absence of an ability to forfeit, what else can you do? Well, there's nothing to prevent a debt action, as it turns out. And we've seen that, as in the Comets case that we've just mentioned, courts don't seem to be unsympathetic to landlords. Otherwise, if you have a distressed tenant who it appears is going to be unlikely to recover, then in some circumstances it might be appropriate to look at negotiating a surrender with them. In an ideal world, they might even pay you a premium, which said premium might happen to equate to some of the rent what they haven't paid. So yeah, that's one thing you could do. But then, I mean, you might find that you get some pushback from tenants, as I mean, if you've got this new extension on ability to forfeit in place until next March, tenants not necessarily going to be rushing to agree anything new with you unless they have to. Although arguably it would be, when the time comes, it would be cleaner to negotiate a surrender rather than let a landlord forfeit their lease, as this again just creates a bad track record. Obviously, though, when landlords do manage to recover premises, if that's what they're kind of determined to do, you've just got to be, this is obvious, but you've just got to be alive to the fact that you're going to kind of be looking at potential liability for business rates kicking in again, and any other property expenses that you'd otherwise have been recharging to the tenants. And I suppose the final option in respect of what else can our landlord do if you've got a tenant not paying rent, or if you think they're in trouble, an alternative is to leave them on the hook for as long as possible, so that those liabilities continue to accrue to you pending the appointment of insolvency practitioners, if things went that way. Right.
So, have any other points of interest arisen, Graeme, in relation to commercial tenancies? The question you may be asking.
Oh yes, well that one was on the tip of my tongue. So yes, actually yes, there have been some interesting points that have arisen, and so the first one, and so this relates to something that we're going to be coming back to in a little bit. So we have had some tenants, or what we've seen is we had some tenants who were itchingly keen to rush out and use their newly extended general permitted development rights to use their hospitality premises to provide takeaway services. So far so good, but then their permitted use clause in their leases says, aha, no, I mean, you've only got a very specific use. But I think we've had a couple of inquiries come up about that, haven't we, Becky?
Yes, absolutely. It is key. Although the planning legislation has been relaxed, it doesn't automatically equate to a relaxation of a permitted user clause. So I think it would be worthwhile checking that if you have been taking advantage of that planning relaxation, just to make sure, if you're a tenant, that you aren't inadvertently breaching the terms of your lease. In terms of service charges, again, I think this is going to be interesting fodder for dispute, particularly for landlords of commercial multi-let buildings, where there is an obligation on that landlord to provide common parts services, particularly with the extensive obligations that have been placed on them for cleaning, sanitising, providing PPE, and those charges are, unfortunately, I think, going to be passed back on to the tenants and occupiers of the building. There will likely be, in most lease clauses, in the service charge provisions, a compliance with laws clause. So if the landlord has to comply with the laws and recommendations of the government, then they will be able to recoup those costs back from the tenant. There's usually also a sort of general sweeping up clause that says, or anything else which is reasonable for the landlord to do in the principles of good estate management. And I don't think anyone's going to be able to argue that COVID compliance is not in the principles of good estate management. So that's going to be an interesting one to watch. I think we'll see where people get to at the end of their respective service charge years and see how many disputes arise out of that. Graeme, what's the news in relation to rent reviews?
Well, so what we've started to see is that, well, as we all know, the pandemic has changed all of our relationships with our business premises. So as a result of that, that kind of feeds into uncertainty as to what we think they're worth and how much we think we ought to be paying for them. And that is inevitably going to start to feed through. That uncertainty is going to start to feed through into open market rent review processes when they're carried out. So that is going to be extremely interesting to watch. But what we are starting to see is that landlords are starting to try to get ahead of this by agreeing on rent review provisions with tenants, whereby you have your standard open market rent at kind of set intervals, but then as like a backup mechanism, you then have some kind of index link mechanism to sit alongside it, so that say your open market rent review or your upwards only open market rent review doesn't actually result in an increase. You then have your RPI sitting alongside in the background to hopefully get you something, even if the open market review doesn't. So that seems to be so essentially people are hedging their bets in terms of rent review provisions.
Indeed. And presumably, I think we're also starting to hear murmurings about turnover rents, but they're not necessarily very landlord
Yeah.
friendly. I think they're more perhaps in the interest of tenants. So that'll be interesting to see. Temporary concessions. So yeah, this can cover a huge range of things, and it's essentially where a landlord and tenant effectively have a side agreement or a side letter. So it can cover a number of areas. So, for example, a reduced rent or a rent repayment plan. But it can also cover things like allowing different uses of the property under the terms of the lease, or allowing sharing of occupation. So we'll see them in relation to, restaurants allowing food pop-ups, or other services to share that space, which hopefully keeps cash flow in the tenant's pocket, and therefore that's an interest to the landlord. And finally, the very interesting one that I've seen a lot of actually in the last 6 months is pandemic clauses in leases. I think tenants are getting very savvy about this. We've had a number of deals come to us from heads of term stage, but also we've been advising tenants to consider it as well, is negotiating specific pandemic clauses in your leases. Now, this can be just for COVID, or it can be any pandemic. It depends how widely the clause is drafted. They do require a specific set of skills. They are or can be quite complex in terms of drafting. So you need to make sure that you get the use of the property right. It's not supposed to be linked to the permitted use, and there is a very specific reason for this. So let's say, for example, you are a retail tenant, your lease says any use within use class A1, you use the property as a greetings card shop. If you were to link the pandemic clauses to the permitted use, technically you could still use that property for the sale of retail sale of food. But obviously that's not what your business is. And the other thing is that you need to make sure that excuse me, I must apologise. My cat's just walked in. I apologise. It's just slightly distracting me. But yeah, either way, the thing to bear in mind is that pandemic clauses are very useful to have for both landlords and tenants. I'm just going to pass you over to Graeme now, just to pick up on the planning points.
Excellent. Thank you. That's a picture. I was looking forward to meeting Becky's cat. Right. So, okay. So now this slide. Now I'm just going to group very quickly with this slide. So, so one thing we know is that the government from the 1st of August 2021, obviously this year, government's introducing a new temporary use class A, which is going to be useful in respect of.
This is the one where there is going to be a general permitted development right to convert properties with use class E, commercial buildings, to residential development. This is going to be really interesting. Now, before everyone starts getting really excited about this new right, there are going to be conditions that need to be complied with before this can be implemented. So, for example, the new permitted development right won't apply to properties where you're in a conservation area, or if it's a listed building. There are also going to be limitations on the amount of space that can be converted under this permitted development right. So I think it's a maximum of 1,500 square metres. But it does allow flexibility for development of town centre areas. So I think that's going to be an interesting development. The other thing to bear in mind is there was an extension the temporary lifespan of a planning consent. So that meant that if you had a planning permission which had a time limit in it, it was automatically given an extension. It's worth noting that that has now come to an end. So if you have a planning permission with a time limit for starting, the clock is now still ticking. One of the interesting things, again, we keep coming back to this, but it seems to be an area of real importance. The General Permitted Development Order allowed takeaway and delivery for pubs and restaurants. That's actually been extended until the 23rd of March 2022. So that's, going to continue on a longer term basis, which I'm sure is very welcome for our colleagues in the hospitality industry. As I mentioned, don't automatically assume that your lease will allow for that extension. So it may be worth getting that concession side letter from a landlord if you don't have that permitted use in your lease. Obviously, if you're in the freehold of your building, then you should be good to go. So Business and Planning Act pavement licenses until the 30th September 2022. So where you want to make an application to extend your service area onto the pavement in front of your premises, they brought in a new streamlined application process. And again, that process has been extended until the 30th September 2022. And interestingly, so far as we can tell, if you make an application for one of these licenses, then it's deemed to automatically give planning consent for your use as a restaurant onto that space. So you wouldn't necessarily need to go and get separate planning permission to extend outside. And the final point to note on planning is that the ministerial statement brought in a streamlined process for variation of site management conditions. And again, it's just a heads up, that came to an end back on the 13th of May 2021. Okay, apologies for my slight absence there. There we go. So Graeme, talk to us about real estate finance and development.
Oh, okay then. Right. Okay. So in a nutshell, if you were a lender, the polite way of describing 2020 would be as a roller coaster. So we know that UK commercial real estate loan origination volumes were down 23% in 2020 relative to 2019. So yeah, that's quite a trail-off. And if you were a commercial lender, you might have been looking at your business projections with a slight sense of panic. We also know that, hedging against this, and we know that UK commercial loan to value ratios hit a record low in 2020, averaging 50 to 55% across the market, which. No, that wasn't. That's good for lenders, but not especially good news if you were looking to borrow the money, as you would have found yourself needing to put in perhaps rather more equity / cash than you might have been planning on it. That said, if you were a seasoned developer with a track record, a successful track record, there didn't necessarily seem to be an apparent shortage of development finance available over the last year. Seemed to us that the same names, and indeed new names, were offering the same or similar products, just at slightly higher rates, which probably doesn't come as a special surprise to anyone. Purely as a coincidence, Shawbrook, we know, have been actively funneling funds into the development market over the last couple of years, and we know that in 2020 they actually hit their target of achieving £1 billion worth of development finance loans a whole year ahead of target, and they were actually accelerating in the number and amount of loans actually made throughout 2020, which perhaps tells you what you need to know about the availability of funding. Bridge lending has remained ubiquitous, it's still available, still popular. It's just that it's possibly slightly harder to get, possibly, and the terms on offer you might like even less than you did before. One pattern, one trend that we've seen is that bridge lenders are paying far more attention and they are much sharper now around establishing what a borrower's intended exit from a loan is going to be, whereas perhaps a couple of 2 or 3 years previously, the question might have been asked, but it it never appeared to have been a showstopper, whereas now, anecdotally, one matter that we've recently acted on, acting for a developer who needed a bridge, as you do, needed a bridge gap potentially for up to a year. And the ultimate exit, when push came to shove, was going to be the sale of the residential property, if it, I mean, their home, if it absolutely came to it. And a couple of the bridge lenders who they were looking at dealing with said, okay, fine, we accept that as your exit, but only provided that you put your home on the market now as a precondition to completion happening. And needless to say, they stopped talking to that particular lenders. It would have sent the wrong messages to, I don't know, their contractors, staff, competitors, and not to mention their neighbours. So yeah, bridge lending, a movable and enjoyable feast. But generally, as a tip for commercial borrowers, and this may fall into the category of pointing out the painfully obvious, but it is more important than ever before, when going for finance, when applying for finance, to you need to make sure that you are as credible and as well prepared as you can possibly be. In an ideal world, you very clearly need to be demonstrating a track record or some involvement with a development that has gone well. Although there doesn't seem to be a shortage of people out there willing to lend into the commercial sector, it is far from money supermarket territory, unfortunately. But there we go. So that is a very rough roundup as to what we see in terms of real estate finance and
So,
development.
what's going on in the region then, Graeme? Do you want to run through some of the highlights?
Okay, we'll just have a very quick whiz through this. So, highlights and development activity in this part of the world seems to be zooming along faster than it ever was before, as the pandemic arguably seems to have increased yet further demand for quality housing in this area. Possibly as an observation, it seemed that roughly a year ago, people were itching to move out of cities and get into the countryside, and that seems to, I mean, perhaps that's one driver for the continued acceleration in activity that we seem to be seeing, as ostensibly more deals are being done now than were being done prior to the first lockdown. I mean, I think what we're seeing is that developers with the means to proceed, financial backing or access to funds, are able to drive some really compelling transactions on increasingly imaginative, creative terms. I think that what we could say is that it, I mean, as an observation, you might say the quality of life and the quality of the area, the region itself, has shielded us from a downturn that seems to have been seen in other parts of the country in terms of development starts. How do we know there's been a downturn, and how can we argue that we might have been shielded from it? Well, that's because we know from a Datcher survey market report, the total number of new construction starts across the UK in the first quarter of 2021 was 87.3% lower than it was in 2020. And then that was 128.8% lower than it was in 2019. Whereas that drop off, and that fairly stark drop off, certainly hasn't followed into that. That hasn't translated into anything that we've seen acting for our clients here.
No. I mean, I would say, Graeme, that we've had probably more instructions of a development nature than we've ever had previously. So I think, that shows the positivity, I think, and, enthusiasm locally for development within the region, which I think is great news for everybody.
Cracking.
So, yeah, I think we've got hopefully high activity levels to look forward to.
I guess so. I mean, it looks that way. I mean, the number of strategic transaction instructions we've received, such as joint ventures and promotions. I mean, we're all seeing a lot of those.
Mm.
We're seeing increasingly creative structures and deals. More people than ever are kind of getting more joint venture queries. Certainly, people saying, "Well, how can we do this? How can we do that?" Oh, I mean, we did act on one recently, didn't we? Where we managed to secure a property for a client, a development site thought to be worth around £2 to £2.5 million, and we put a joint venture together for the client where they were able to acquire the property on day one for a quarter of its likely value, with the rest of the purchase price to be deferred and paid as profit share as the development progresses. So, whereas a couple of years ago, if you approached a landowner with that, they wouldn't have laughed at you, but the conversation might not have lasted very long.
Mm.
So, but otherwise, yeah.
There's a willingness, I think, to have a more proactive approach to the sharing of expertise and the sharing of assets. So, the landowner's got the land, the developer's got the experience, and actually, I think we're starting to see a real trend towards, that profit sharing approach where, the structure is favoured neither in one party's favour or the other. It tends to be a really kind of collaborative approach we're seeing here.
Yeah.
So I'm just going to pick up the last point about retail and office leases. Yes, not quite as many. I think the ones that we're seeing are clients who are now getting to the point where they've perhaps been putting off lease renewals for offices and they're now going ahead. Whether we start to see a trend towards smaller spaces for offices, I don't know. Certainly, Pretties will be relocating later this year, and our view has been that actually a lot of our staff are really happy working part time from home, as you can see, cat excluded. But it's something that they're really, it's in the well-being of their staff actually that it works better for. So our space that we require has actually gotten smaller. I think that's likely to be a trend across the offices market. Conversely, leases for warehouse and warehousing premises, absolutely bonkers. Things are going off the market very quickly. We're being presented with some extremely short deadlines to get leases completed because there is such great competition for units in good areas with good transport links. So that's been challenging, but also equally exciting. Be really interested to hear from some of our attendees if that's your experience of the lettings market, if that's what you're seeing, and perhaps we can have a chat about that in a minute. If anyone's got any comments or questions, please add them in the chat box. So what we're going to do now, just have a quick final poll of the day. And so we want to know if you work in an office and you have been working at home, are you going back to the office full time? So there we go. Let me just put that on the screen. So it's how do you plan to work in the future? So we made it quite simple choice: 100% at home, 100% in the office, or mixed. I think I can potentially anticipate what the results here are going to be, but I could be wrong. It has been known in the past that I have been wrong. Only once, but yeah. Okay. Right. Oh, yeah. 6 people have voted. We've got 2 people still thinking about it. Right. I'm going to, those people can still think about it. I'm going to end the voting now and share the results. So we've got 50%. That's quite a big number. Are going to have mixed, which, realistically, if we think back to pre-March 2020, would any of us ever thought that we would be spending quite so much time working from home? I think it's really changed the culture of the working culture of the country. And of course, that's going to have an impact on, the commercial property market, rental lettings, etc. And ultimately, those big pension funds that own office buildings, are going to be the ones seeing the impact of that. So I think there is going to be a driver to more flexible uses of those spaces, short-term lettings, meeting rooms, virtual meeting rooms, short-term meeting rooms. I can really see that becoming a real driver and probably a change away from that sort of 5-10 year office lease that we've been seeing. Okay. So just onto the last and final slide. So we had a bit of a go at, go back. We've had a bit of a go at coming up with what we think may happen in the next sort of 12 months or so. But these are our thoughts based on what we've seen. So Graeme, why don't you run us through these?
Okie doke. So we're anticipating that residential development activity is probably going to continue to grow as the pandemic appears to have further driven demand for quality accommodation in the area. We're seeing instructions on build to rent schemes as people are figuring that, well, I can actually get an income from these. It's a solid investment. Build properties, rent them out. I mean, there are some big names getting into that area. Consistent income rather than one-off kind of boom. Freeport, I think for Freeport East, I think we're expecting further details to be announced about that in August. I think some of the specifics have got yet to be determined, but and there's a question as to exactly which area is going to be zoned for. I mean, we know it's Felixstowe Harwich, but we need to see kind of which bit. And the question mark as to who it's going to benefit is unclear. As yet, I guess we know that the biggest landowner around, certainly the Felixstowe side, as far as I'm aware, is Trinity College, Cambridge. So possibly it's going to be the college that stands to be the biggest winner from this in some shape. But we'll see. Supply and demand, expect that to remain strong. So it's all looking reasonably good.
Yeah, I know. I think we wanted to just end this on a really positive note, just to say that, we really do think that, the market for commercial and development and, all this kind of stuff still remains really strong, and there are opportunities out there. So that is it for the presentation side. So we would like to invite anyone who wants to ask us a question. You've got us here, you may as well ask us a question, or who have got any sort of comments or feelings about their own view on the market, or where they're going to be working in the future. Please feel free to ask us a question and we will do our best to answer it. I think, Graeme, we've shocked everyone, unless we've answered all of their questions.
Hang on, let me just type one in.
Hopefully you know the answer to your own question. That would be good.
I don't know. I wouldn't bet on it.
Okay.
Oh, someone's typing.
Okay. Excellent. Well, whilst we wait for any questions to come in, just like to say a big thank you to you all for coming. We really appreciate you coming to sort of listen to us today, and hopefully what we've said has been interesting. I have to say it was very much a kind of last minute variation. Thank you very much, government, for changing your position less than 24 hours before our presentation. Really grateful for that, but hopefully it shows that we are in fact on the ball, so we do keep up to date. So if you do need any advice, or you want to talk to us about any leases or commercial property matters, our details will be at the end of this presentation, and you can contact us or the team for any discussions about anything that you might wish to do so in the future. Oh, Pat's commented, staff shortages being reported in care, construction, hospitality, wage increases of 18% being reported. Assigned cities will draw folks back. That's an interesting one, Pat. I think my other half is he actually runs a jobs board, so I can definitely confirm the care vacancies point. Hospitality, I'm constantly seeing jobs for hospitality. I think unfortunately because of the pandemic they did unfortunately lose a lot of very good and talented staff who may have decided to go off and pursue a career elsewhere. Thanks, Dave. Richard is fine. Richard is my cat. Not a short name for Dave Richardson. So yeah, I don't know. It's interesting about the London point. I mean, certainly just on the residential property side, we've seen the values of residential property in this area shoot up. So to me, that's a sign that there is more demand than supply for residential properties, which leads me to believe that perhaps more people are moving to the area. So any particular questions about leases or landlord and tenant, or commercial property finance, anything like that we can assist with whilst you have us? Everyone's gone a bit quiet. If not, that's absolutely fine. It's been our pleasure to host everyone here this afternoon. Thank you so much for coming. Of course, if you do feel like you have any questions, here are our contact details. Amy Ellis will be emailing round copies of the slides to everyone who attended today so that you've got them on hand in case you have any further questions. And I would please ask before you go, if you would be so kind as to fill in the feedback form. That's always really valuable. Obviously, if there were parts that you wanted you didn't enjoy as much, please explain why, and we can obviously work on those in the future. But hopefully everything that we talked about today you found interesting, and yeah, we welcome you along to the next one. It would also be really helpful if in your comments section you put down suggestions of topics for further webinars, and then we can take those into consideration when we plan our next one.